Now, some unions are calling on government to ensure that companies that get COVID-19 relief do not do so, or rather they do so on condition that they don't retrench workers. Now, is there any kind of legal framework that could be used to make this happen? For more on that question, we are joined now in conversation by labor law consultant Tony Healy. Tony, good evening and thank you for your time tonight. Do we have a legal instrument of some sort that could assist the labor movements with this particular request?
Well, good evening and good evening to the viewers. One needs to understand that even though we have, as you've been discussing in your show, the COVID-19 TERS UIF benefits, employers are still, as far as the law is concerned at least, allowed to retrench. They have to go through certain procedures, but they are allowed to do so. I think that's perhaps the bad news. The good news is, I think, that the two bits of good news, and the first one is that we've seen anecdotally, at least in our consultancy, that there is a sense amongst certain employers who were contemplating retrenchments. Certain of them are reconsidering that now that we're seeing the move to level 3 from next week. Secondly, many employers are also, particularly in the hospitality industry, for example, are hoping that there's going to be an extension of the COVID-19 TERS benefit, because the hospitality industry, as you will well know, has been particularly hard hit. So the short answer to your question is retrenchment is still possible, but there are ways of mitigating the potential large numbers of retrenchments that at least have been predicted.
So it seems, Labour is hoping that COVID-19 might bring a little bit of a power dynamics shift here, where, as you are saying, up until this point, and as you're saying, it continues to be, that the power lies with the employer to make the decision on when to retrench and when not to retrench. But with COVID-19, a shift in that power dynamic where an employee can also maybe come into the conversation.
Well, I'm not so sure that that's necessarily the case. The fact of the matter is that many businesses have been decimated by COVID-19. And when we talk about the bloodbath, I think it's important, the bloodbath of jobs at least, I think it's important to understand that that's only true, that's true in certain sectors and not in others. So for example, in essential service sectors, there have been no job losses, and there are unlikely to be any. Food retail, fuel retail, essential services, those kinds of industries are not really going to be affected. There are going to be very few, if any, job losses in those areas. But there are other sectors that have been particularly hard hit. As I say, hospitality is one of them. We must remember that, there's probably about 1 million employees related to the hospitality sector, and hotels are not expecting to open till October, for example. And when they do open, they're expecting to recover very slowly. And what makes that even more difficult is the fact that it is a sector within which there are normally fantastic job opportunities because it's labor intensive. So not only have we lost an industry in the hospitality industry, which has been hit so badly, it's an industry that employs a lot of people. And it's also, unfortunately, an industry that's unlikely to recover quickly. But I think, the green shoots are hopefully the COVID-19 UIF TERS benefits can be extended for industries like that, so that it will serve at least as an incentive for certain employers who are contemplating retrenchments deciding not to do so.
These are complex, hard times, Tony. If you look at the aviation sector, there's something very interesting that is happening there at South African Airways, where you've got workers going to the business rescue practitioners saying, well, we're trying to serve the airline, so we agree to half our salary. But it looks like the business rescue practitioner did not pay attention to that particular offer that was given by the employees. Can people go and make that sort of agreement, and could that be the basis on which the company says, well, we will not go ahead with the retrenchment?
Very much so, and that's one of the principal alternatives to retrenchment, is to agree short hours. The dilemma that airlines have, for example, and the hospitality industry more broadly as well, and the events industry and the restaurants and pubs and clubs, is that they're not receiving any income at all. It's not as if they're receiving partial income. So they're receiving no income. So that's what makes those kinds, it that much more difficult in those kinds of industries, even to agree a short working week arrangement as an alternative to dismissal.
What's your view on the ruling that was given to the South African Airways employees via the National Union of Metal Workers by Judge Fanike, who said, well, you cannot retrench unless there is a business rescue plan in place? One, do you think SAA and the business rescue practitioners are correct to challenge that ruling, and what are the implications of that ruling?
Look, that's an extremely difficult dispute. SAA, it's widely known that SAA is in a parlous condition. It's moving from one model to another, it would appear. It also has no revenue. The judge in that particular judgment is essentially saying, well, the court is not satisfied that SAA has made out a case where they've exhausted all the alternatives, and perhaps given my interpretation of the judgment, at least, is it's not given enough forethought to what an alternative SAA will look like that has the potential to preserve jobs. So if you ask, is it realistic or right for the business rescue practitioners to challenge that? Well, they obviously have a case that says they have no alternative given the circumstances, and time will tell whether that argument prevails.
And in as far as that whole package that says part of the considerations, as you're putting it, for retrenchment would be to put on paper and on the table a business rescue plan. That certainly will have a lot of implications for companies who would want to apply for retrenchment going forward.
Well, yes. I think one must remember that in any retrenchment exercise, the employer must be able to show that it's exhausted all measures other than retrenchment to try and rescue the financial circumstances in which it finds itself. And that's no less true for SAA than it is for anybody else.